Hi, Chris Opfer from Bloomberg Law. I'm here at Littler Mendelson's Executive Employer Conference, joined at the news table today by two Littler attorneys. Happy to be joined by Trish Martin, a shareholder with the firm, and by Aaron Cruz, the firm's Chief Data Analytics Officer. We're here to talk about pay equity. Some folks are saying there's a wave in terms of state laws that are coming on the issue of pay equity. New Jersey, of course, is at the front of that. But can you tell us, Trish, a little bit about what's happening at the state level with pay equity?
Sure. Last year and continuing into this year, we've seen lots of state governments and local governments pass different types of pay equity laws to try to remedy the historic gap between the amount of money women earn for a job as compared with how much men earn for doing the same job.
Is there one or two states in particular that jump out to you as, in terms of an example of what's going on?
Sure. California has a very strong pay equity law. In addition, Massachusetts has a new law that goes into effect this summer that is very strong and actually provides an employer with a defense if they do a self-audit to figure out if they have a pay equity issue, and if they identify one, if they take steps to remedy that. Even if they don't entirely solve the problem, they have an affirmative defense to a lawsuit for a period of 3 years of time. New York and New Jersey have passed very strong laws. New Jersey's new law is particularly strong because while normally employees can go back to recover back wages for 2 years, in New Jersey under this new statute, it's actually 6 years they can go back to get back wages on. And also, while most state statutes have something called liquidated damages, which is where you double the back wages as a penalty, in New Jersey it's actually 3 times the damages, same for New York.
So, Aaron, I think the wave has probably some employers taking another look at their pay compensation policies and maybe taking a look even for the first time at some of their data. If an employer comes to you and says, look, I want to make sure we're doing the right thing and we're in compliance, but I don't even know where to start, what do you tell them?
So my starting position is always do the audit. An audit is the best place that an employer can start in terms of getting grips on what's actually going on. And a lot of folks kind of struggle with where is the data that you would use for an audit, and that's actually a relatively simple for most organizations kind of conversation, because you start with the company's HRIS system. So we've been building tools for the last little bit to help enable this process and make it easier and faster for clients. And so we actually take an export from the client's HRIS system, we roll it into a tool that we built in-house called the Littler Pay Equity Assessment, and we use that in conjunction with somebody like Trish. So she'll actually sit down with the data, with the tools, sit down with the client, and begin to start modeling out both what the client thinks is driving its comp, but then also we can model out and identify what's actually driving comp to figure out where disparities come from and what steps are going to be necessary to potentially remediate some of that issue.
And what happens if there is an issue? I mean, remediation steps, there's probably a lot of different things employers could do. What do you suggest?
So the first thing we do when we get the data is we talk the client through what do they think is driving their compensation and what jobs are similar, because these pay equity laws only require the same pay for similar work. So that's a little bit of an art. When we get the results back, we look at it company-wide and we say, how does it look company-wide? And then we sort of narrow it down to see are there specific areas, jobs, states where there are issues. If there are, we look at those in particular. We see if there are any outliers that are skewing the results. And we really talk to the client about, are there other things driving pay that maybe you haven't told us about that might explain this gender disparity? Many times there are, and when we add those control variables, it turns out there's not a problem. If we're not able to explain away the variances based on, legitimate control variables, then we start talking to them about what steps to take to remedy it. That could be increasing the pay of certain individuals so that that disparity goes away entirely. It can be other steps like making sure that when you hire new employees, you don't ask them what they were making in the past, because if in the past they were paid less because of their gender through intentional or unintentional discrimination, you don't want to perpetuate that in the new job. And once you bring an employee in, it's sort of hard to fix their pay over time. Usually disparities get wider. So training managers on how to set compensation and making sure that they're actually setting it the way the company wants them to is often a very good step for remediation.
There's been a lot of debate about whether or not employers should be able to ask applicants about their previous salary history, and I know that there are some bans floating around. Is your general advice to employers to just avoid that question to avoid the problems that could come with it?
I think it's a best practice not to ask it. There are certainly some states and some cities that have disallowed it entirely under federal law in some circuits. Prior salary is a permissible reason for having a pay equity under the Equal Pay Act, but in many circuits that's not true. So the best practice for sure is just to avoid that question.
Got it.
Well, to carry on that just a little bit, the other thing too, inside of your business, it becomes very difficult and very unwieldy if you're a business of any size to start trying to manage that process of those gaps if you're bringing people in based on their prior salaries. Whereas if you are setting sort of salary parameters for jobs and everybody's more or less in the same place, it becomes a much easier process for dealing with that, both from an understanding level, but also from a mitigation and remediation level.
Sorry.
I was just going to add that from a defense of litigation standpoint, even if you're in a jurisdiction where that's allowed, if you get a lawsuit 10 years down the road, it's sort of hard to figure out why 10 years ago you set the compensation the way you set it.
Especially the way the laws are changing
Yes.
so rapidly. Well, I think that's all the time that we have. Thanks.